that is the one you want.
I think we're doing it. So hold on.
It looks like we are.
Yeah.
Setting up your meeting. All right.
Working.
All right, we're live.
Okay, sounds good. Well, good afternoon, everyone. We're going to begin our, I guess, first meeting of the Environment Subcommittee of EHE. We have one bill on the agenda. This is Bill SB 70. This is Senator Patterson's bill. I don't actually see Senator Patterson on, but the bill has already been heard. It's been referred to subcommittee. And I know that there's been some amendments that have been put forward already. And I guess as soon as committee counsel gets back to her desk, I might ask if we can just go over briefly the amendments that have been offered so we can start there as a starting point for discussion. Ms. Morton, are you there?
Senator Lamb?
Yeah.
I think we could also, before she gets into the amendments, it's been a while since the hearing, just a real quick recap of the bill and before we go into the amendment, if that's okay.
Sure. So I see Ms. Morton's joined us. Are you able to provide just a quick, few seconds of a recap of the bill so that the members are brought up to speed?
Yeah, of course. So again, we're on Senate Bill 70, Environment, Mold Inspections, Standards, Reportings, and Penalties. The bill requires the Maryland Department of the Environment, in consultation with the Maryland Department of Health, the Department of Housing and Community
I've worked with them
Development.
over the years, but not to the degree you have.
Aaron?
There we go.
And the Department of General Services to adopt regulations that establish uniform standards for mold assessment and remediation as specified by June 1st, 2023. Among other things, the regulations must require local jurisdictions to conduct annual mold inspections of all rental dwellings within the jurisdiction. The bill also establishes provisions relating to 1, enforcement and penalties, and 2, rent escrow rights and protections for specified tenants. And just to jog your heads a little bit on what the concerns were about this bill that were raised at the bill hearing, I'd say there was pretty broad consensus by the advocates for the bill that mold is a problem. It can cause serious health concerns. There were issues raised by particularly some of the tenants' rights groups and some of the people who are coming from like the legal aid world about the difficulty right now of getting landlords to remediate mold in rental housing units. So those were sort of the proponents of the bill. The opposition came in part from the counties, just in terms of the burden that was going to be placed on local governments to conduct annual inspections of every rental dwelling unit, concerns about the expertise and ability of local health departments and local environmental departments to really do the types of mold inspections that the bill was considering. There were also concerns sort of raised in the fiscal note about the expense of putting this new sort of regulatory requirements on the Department of the Environment, and sort of the fact that they don't currently have anything like a real mold expertise there. So that was something they would have to build up under the bill. And then concerns from sort of the apartments and buildings and landlord representatives of the way both the rent escrow provisions were drafted and also the requirements that would be placed on landlords in the bill.
And then just to remind folks, so MACO, MML, the Maryland Association of County Health Officers, the Conference of Environmental Health Directors, they were either unfavorable or favorable with heavy amendments. The folks that were favorable were Green and Healthy Homes Initiative, Legal Aid, Renters United Maryland. And then there were unfavorables from the landlord type representatives, MMHA, the Builders Association, and Maryland Realtors. Senator Carrozza, you had a question?
Please unmute.
Thank you. And thank you, April, for that rundown. and I know we're going to go through the amendment, but just for an understanding, when you walk through the bill, it looks like the issues were prompted mainly by some of the tenants and organizations, primarily tenants that are in public housing, and then I was trying to understand the scope of the bill and what, if local jurisdictions are required to do anything at this point. So I just was trying to put the pieces of the public housing tenants to the scope of the bill and to what, if there's any requirements now on anyone for mold inspection.
So the bill is, as it came in, is drafted very broadly. It applies to all rental dwelling units, both public housing and not. In terms of, and in terms of the people who are advocating for the bill, I would not say it was limited to advocates for tenants and public housing. And we do have representatives from various groups on this Zoom right now. But I do think the concerns are broader than just public housing.
Yeah, and I think if you look at the written testimony too, it is broader than just kind of public housing per se. Sorry, Ms. Morton, go ahead.
No, fine. In terms of what is required right now, I mean, there's nothing. I'm not as familiar with the public housing side of things and whether there's maybe federal requirements, or there might be requirements in some of the counties already for the public housing. But there is no across the board, there is no state requirement for any sort of mold inspection in any rental units. There are, and again, we have some people from county health departments here. There are inspections that already occur that have to do with kind of the habitability codes in the counties. And those tend to apply though to multi-unit buildings. So those are the larger apartment buildings.
Okay. Now, I know there were some amendments that were offered, and I guess out of deference to the sponsor, were there sponsor amendments that were there amendments offered as sponsor as well?
So Senator Patterson gave me some kind of draft language, and I can send that around, or I can screen share, but
if you want to just verbally go over them briefly, just out of deference to that, and then we can also look at some of the other amendments too.
Sure. So Senator Patterson suggested potentially striking the language requiring a local jurisdiction to conduct an annual mold inspection of all rental dwelling units. And then conceptually adding language to qualify that local inspections are to be conducted by local code enforcement inspectors in performance of their regular duties. So not requiring the annual inspections, but to require them to do the mold inspections when they're performing other inspections. Add language to qualify local inspections to be non-mechanical. Require local inspectors to report suspected mold to landlords and notify the landlord of their responsibility for testing and remediation. Qualify for local inspectors what they observe to be mold. So I think the idea there being that they don't necessarily have to test for mold, just that they can, whatever they are observing to be mold, and include that local jurisdictions may charge a fine for non-compliance.
Okay. Any questions about that? If not, I think some of those provisions were actually built into other amendments that Senator Pinsky had offered. If there's no questions there, maybe either Ms. Morton or the sponsor of the amendment, do you want to speak to, Senator Pinsky, do you want to speak to your amendment?
Well, let me just say briefly.
Are there amendments we should be looking at? I only have this House Bill 129 amended. Are there other amendments floating around?
There should be.
To be honest, Senator, I don't remember my amendments, but let me speak more generically, very briefly.
Sure. Go ahead.
Years ago, we never had lead paint legislation. and people began to realize we had a problem with lead paint and it was affecting children's health. And we slowly developed a process and a program for dealing with lead paint. And I guess I'd put this in a similar category. I think this will get our foot in the door if we acknowledge it's a problem. That's the first question. Is it a problem? It already is in schools. I mean, I've worked in schools when parents complain their kids come home sick and the school system goes in and does a review and check to see if there's mold, and then they either don't do anything or they remediate. So it's already happening in some institutions. I just think we should figure out what is a reasonable and logical first step that makes sense. And not that we have to start from scratch, but if there's a problem, we have to figure it out. You know, I think everyone agrees somebody like the department has to set up a standard for what is mold infestation. I mean, and I think we need to do that. And then, so if we get to a point where we think there should be testing, we have to have a standard so they can test to say there's a problem or not a problem. You know, I think we shouldn't get stuck on the preliminary solutions of tests every year or who pays. I would suggest working backwards of the key question we need to answer and shape a bill in whatever we think is appropriate to begin this process. So that's a methodology comment.
Okay. So it's good to keep that endpoint in mind, you know, as we try to find a way forward for this bill. You know, I know that Senator Pinsky did offer some amendments, I think, that were drafted up. Ms. Morton, can you go over those amendments, or can we circulate those amendments to the group? I think, I thought they were circulated, but maybe I'm wrong.
Yeah, and I apologize. I think there was some miscommunication there, but I just sent them. I might be able to throw them up on a screen if you give me a second. Whoops, nope.
And just for the members, this is just a starting point. I don't know how wedded the sponsor of the amendment feels to you know, his amendments, but I think it's a good place to at least start the discussion.
And Mr. Chairman, NACO also has offered some amendments in the last couple of days.
Yeah.
That might also be another, if not starting point, a point of departure.
I figured I'd start with the chairman's amendments first.
Okay. You can or you can't, really.
All right, so can people see the screen now?
Yes.
Okay. So, and again, I think these amendments, and I did just send them by email too, if that's easier, if people would prefer to pull it up that way. But again, these are, I think we're sort of put together as a discussion and trying to respond to some of the original concerns. I will say these have been shared with NACO and the county health and environmental departments, and we'll go through some sort of counter proposals that they have offered after this. I think they were still concerned with how much kind of new authority and responsibility was going to be placed on the locals under these amendments. So just keep that in mind as we go through this. So essentially, and we'll start here because this is really where the kind of the meat of the amendment is. It would still require the Department of the Environment to come up with these standards for habitable dampness, identifying and evaluating the presence of mold, mold remediation standards, and risk reduction standards. And then we'll also say that the MDE regulations should require local health officers and code enforcement agencies to inspect for visual evidence of mold as part of any regular inspections of rental dwelling units. Then sort of strikes a lot of this language that goes more specifically into requiring the department to verify third-party inspectors and requiring annual inspections, and instead adds new language establishing an affirmative duty for landlords to maintain premises and conditioned as to prevent the accumulation of moisture and the growth of mold. And then to require the landlord at the landlord's expense to cause a rental dwelling unit to be inspected for mold in accordance with department regulations. So it's a little bit quiet as to what that inspection would actually have to entail. But upon each change of occupancy and no later than 7 days after receiving written or electronic notice of a suspected mold hazard from a tenant or from a local health or environmental department. The landlord would then be required to promptly remediate or to remediate in accordance again with department regulations within just as a reasonable amount of time. It doesn't specify what that time frame would be after receiving a mold remediation order from a local.
I think Senator Kagan has a question.
Do you mind, Ms. Morton, if I interrupt while we're going through this?
No.
Okay, I appreciate it. Thank you, Mr. Chairman. In what you just read, no later than 7 days after written or electronic notice of a suspected mold hazard, and then C sub 1 immediately afterwards, the landlord has to remediate. What if it's a suspected mold hazard that's actually not a mold hazard? The landlord is already remediating something that turns out not to be a thing?
No, so subsection B, so that's the inspection requirement. So they're required to inspect within 7 days.
Yes.
Upon a change of occupancy or within 7 days after receiving, notice from a tenant saying, I think I've got a mold hazard, or the local government saying, we think there's a mold hazard.
Mhm.
Subsection C then says that they have to promptly remediate within a reasonable amount of time after receiving either a specific mold remediation order. So if the county did think for whatever reason that was pretty sure it was a mold hazard, or the results from an inspection under that first.
Okay.
So the first subsection B is about when do you have to inspect, subsection C is about when do you have to remediate.
Okay, so it's down in C3, C2.
1 and 2.
Yeah. That we're gonna be sure that there is mold before you have to remediate. It just seems a little inside out, but okay, I appreciate it.
And again, this was sort of thrown together conceptually, so they're not finalized, they're not perfect amendments.
Okay, well,
And
maybe
all
it
of
might,
this is for discussion purposes.
I'm not a bill drafter and you're the expert. Maybe some version of unpretzeling that might be helpful for a reader. Thank you, Mr. Chairman.
And if I, Mr. Subcommittee Chairman, these were done early on, and they still might be too stringent, given that we're taking our first step. So I'm really not here to promote those amendments. I asked April to move it, so I'm not sure they should act as a starting point. I mean, I'm open to the will of the subcommittee. I don't.
Yeah, I think there were concerns coming out of MML and MACO because of the requirements for the local health departments still continue to do these inspections, and so I think they were feeling that that's probably overly burdensome to them. The House sponsor has worked with MML and MACO in the interim to try to come up with some language that they would feel comfortable with, and I think Ms. Morton, if you want to pivot to that, that's I think the Delegate Henson reprint that went out to the members of the subcommittee. We can pivot to that, and that one does soften the language that had previously imposed a requirement on local health departments to conduct these inspections, and also softens some other language too for requirements to MDE and the follow-up inspections itself. So maybe we can move to that. And if you want to present that, this is, I presume, and I think we have Mr. Fiore and Mr. Butler from MACO and MML on here who can speak to this amendment. I presume that you'd be more comfortable with this posture, right? Ms. Morton, do you want to go ahead and run through that?
Sure. Let me throw those up on the screen. Okay. So these amendments take a slightly different approach. Again, striking the language that would require a local jurisdiction to conduct an annual mold inspection, and language requiring the regulations to authorize mold inspections to be performed in conjunction with other inspection, and instead very explicitly requiring MDE to establish a process for qualified mold inspections, and establish a process for qualified inspectors to perform those qualified mold inspections, including a process for the department to verify that a qualified inspector is qualified to perform the mold inspections. So again, this would really shift the requirement for, or the authority for inspections to kind of third-party inspectors, but would require MDE to be sort of regulating that field. So it's important to point out right now in Maryland, there is no license, there is no kind of state certification or license process for mold inspectors. The majority of the kind of the new language in this approach is actually added to the public safety article and an existing statute having to do with the enforcement of the minimum livability code. And so what this would do is it would add language saying that a political subdivision must require a landlord of a rental dwelling unit to have any mold or potential mold identified in carrying out this section. So this is the kind of the general inspections that local jurisdictions are already doing to enforce the minimum livability code, to have the unit inspected by a qualified inspector as described under the environment article. So that would mean a qualified inspector that was sort of registered with the Department of the Environment.
Okay, does that bring us to the end of the reprint?
Yep.
Okay. So discussion on this version of amendments.
Can I ask April one question? And then
Yes, go ahead.
I'll for a few minutes. What prompts the inspection? In other words, I'm trying to figure out on the second page of amendments. I understand qualifying a qualified inspector, setting the standards. It says the department shall establish a process for qualified mold inspections. And then it talks about the results of the mold inspection and who pays for it. But what prompts it under this language in this proposal?
So my understanding, and again, I think maybe somebody from one of the county departments could speak to this a little bit better, but my understanding is that the prompt here is whatever inspections that are, the only prompt that would be included in this amended version of the bill would be a local inspector who, in the course of their duties enforcing the minimum habitability codes or minimum livability codes, thought there was a mold issue, that would be the trigger. And if somebody from MACO wants to contradict me or clarify something.
No, I think that's absolutely right. I think, if we're already in a unit for the purposes of a livability code, either complaint or a regular inspection under our livability codes, then this would require us to, and we see a problem related to mold, this would require us to then notify that landlord that they have to pursue testing and potentially remediation based on a MDE regulated qualified mold inspection.
Would the inspector of the livability code have to see some kind of threshold to tell the manager they have to do a mold test? I mean,
So that's where things get a little more tricky. Establishing a clear threshold of when there is an issue and when there isn't is difficult. I think in several jurisdictions, when they see an issue with related to mold, none of our folks are equipped to do any sort of on the ground real inspection related to mold. We're not mold experts. That would require a ton of expertise and training on our behalf. So when we see something that we find to be an issue, some jurisdictions can go ahead and cite for unsanitary conditions or something related to that matter. But this leaves it up a little more open-ended, and it's sort of at our discretion. And it says if we see an issue related to mold, then we then have to have them pursue a qualified inspection. So it's sort of a trigger for a trigger, if you will.
thank you.
Mr.
Senator Kagan.
Subcommittee. Thank you, Senator Lamb. Two questions following up on Senator Pinsky, Chairman Pinsky's question. One is, what's the process of becoming a certified mold inspector? How long does it take? How expensive is it? How often are they recertified? And then is there a tenant responsibility piece of I have mold, but oops, it's because I never cleaned my house?
I can maybe speak to that, Senator. The way we drafted the bill kind of asks the department to establish this qualified mold inspector process that doesn't currently exist to my knowledge. So it's something that would need to be created. And the bill also asks that they create the registry and the qualifications that are necessary. As to your second question, I believe that might be best addressed by an amendment in Senator Pinsky's packet. We did not have that in ours, but he does have some language in there that might satisfy your question.
Yeah, to the first part, the department would set up regulations as to what a qualified inspector would be. There's some, I think, minimum requirements here that state that it has to be in alignment with US EPA 2008 mold remediation kind of guidelines that are in place. And then as long as these mold inspectors met those qualifications, then they could be listed in this registry.
Thank you.
Any other questions? Okay, seeing no other, Senator Carrozza? Go ahead.
Okay, and this could probably be for either MML or MACO. I'm just trying to understand what you proposed as I just reading through it. Right now, there's no process that if there is a serious mold issue for either someone to either report it or the local health department, I guess, is not involved at this point. And I think what I'm understanding is with what you're proposing, if you walk through the process, would the complaints come in through the local health department or a local health inspector or other inspections identifies a mold issue, whatever that trigger is, whether it's a complaint or noticed on inspection, at that point, would the local health officer be responsible for then notifying MDE? And what isn't in place yet is that there's really no process in MDE yet to, even if they were notified, what that process might look like once MDE is notified. So if you could just maybe flesh out walking me through the process, if you could.
And I know we have Mr. Welch too from the Conference of Environmental Health Directors.
Okay.
He may have also specific expertise as to how this might work too. But looks like Mr. Fiore, you were going to say something?
Yeah, I'm happy to address that question, Senator. The way
you can start. Go ahead.
The way we envision this playing out in a very basic format is the local jurisdiction, when they're doing the inspection, sees what they believe to be mold. Then they notify the landlord of their responsibility to have it remediated or tested by the third party. So we don't really need to go back to MDE at that standpoint. What we believe the more appropriate enforcement mechanism from there is actually the tenant escrow mechanism that's described in the bill. That gets us out of any disputes between a landlord and a tenant, and also doesn't require jurisdictions to have the administrative burden of enforcing every mold inspection that's been required.
Mr. Welch, do you have anything to add to that?
No, I'd concur with basically what you just said.
Okay. Senator Cruz, does that answer your question? Okay. Are there any other questions from members about the amendment that is before us now? Any input from Senator Carrozza?
Thank you. Thank you, Senator Lamb. This is a new issue for me, so I'm really trying to just understand it. When you went to the part about the not being involved between the, if there's a dispute between the landlord and the tenant, and I guess you're trying to have the local jurisdiction removed from that process. And what was the next step? And I haven't read line for line, is when you said that you would then tap into the, was it an escrow? I'm just not up to speed on that part of the bill.
Senator, I'm sure someone else can describe the escrow process a little bit better than I can, but
Somebody.
the ability for a tenant to withhold rent as the enforcement mechanism, so they don't have to pay essentially their rent until the process is remediated. And again, there are people on this call who can probably speak to how that actually happens better than I can.
Yeah.
Mr. Greenfield, since you represent MMHA, do you want to illuminate a little bit more on that question?
Thank you for the question, Senator. And April, my apologies because I wasn't on mute when I first arrived. So thank you for cleaning that up. My apologies. So what would happen, Senator, is in this case is the tenant would go to court and ask to open up a rent escrow account. And there would be the matter would be before a judge, and the judge would determine whether in fact it needs to go, the money needs to be paid into an escrow account while it's being inspected, and determining exactly who's responsible, which is a whole separate issue we have with this bill in terms of what Senator Kagan mentioned. The tenant's conduct is part of this and needs to be considered within the confines of this bill. But the rent escrow process would allow the tenant in this case to put the money up, depending upon the decision of the court, put it into an escrow account until this problem is remedied. And there's existing, and frankly, this bill, I think, sets up a duplicative process because it can already use rent escrow, which is currently in statute.
Okay, just so I understand how that works. So once this mold issue's been identified, and there's now maybe an issue to be resolved between the tenant and the landlord, rather than pay the rent to the landlord, the tenant pays into this escrow until the issue is resolved?
That's correct. And the court, and Mr. Countess, who deals with this far more than I do, the court will then make a determination and release the money, assuming that the landlord has addressed it comprehensively, will then release those funds to the landlord for payment of the rent.
So it's a way to hold the landlord accountable to fix the mold.
That's exactly correct. The problem, of course,
once it's been determined where I guess the responsibility might be.
Yeah, that gets complicated because ultimately it's the landlord's responsibility because it's his or her property. However, it is really, problematic that it could be the tenant's conduct that causes the mold, and it still needs to be remedied because it's a serious situation.
That was actually, I don't know if any of the sort of tenants advocates are still on the call, but I was wondering actually why the choice was made to make a new rent escrow provision rather than putting this into current. It's real property 8-211 has to do with the correction of dangerous defects. Does anybody, I was just.
And to tag on to that, whether it's the advocates or Mr. Greenfield can respond, how hard or difficult is it to utilize that that mechanism to adjudicate or to resolve these mold cases, right?
So
Go ahead, Mr. Countless.
Yeah, sure. So if I could just maybe go back, I don't want to take too much time of the committee, but there are a couple of problems I think. Let me describe the process now and what usually.
Can I just briefly, can you just say who you represent?
Sure, I'm sorry, I did not. My name is Gregory Kas. I'm from Maryland Legal Aid, and I'm director of advocacy for housing and community economic development. So I do a lot of landlord tenant stuff and have done it for years. So what usually happens in this process is the tenant either in the rent escrow process, the tenant either notifies the landlord either in writing or the landlord may have actual knowledge of a condition. The rent escrow law gives after that notification, gives the landlord a time period to make the repairs. It's usually presumed to be 30 days unless it's some sort of emergency condition. If that repair is not made, then and only then would a court determine, in fact, that the tenant is justified in withholding their rent. And as a part of the relief that they would ask for, they would ask that those rent monies be put into an escrow account until such time, to the satisfaction of the court, the particular condition is repaired. And now the process for the court in doing that, it may differ a little bit from county to county. For instance, in Baltimore City, they have what they call court inspectors, and what they are inspectors that work for the local housing and community development. They're inspectors that go out and do their general inspections among all the rest of their duties. But these folks are usually assigned to the court to handle these sort of cases. They go out, they conduct an inspection, and if they find, and then they produce that report and give it to the court. The difference that I see here is that I'm trying to understand the amendments and the trigger, and it seems that an inspector will go out, they'll note that it's a problem, but because many of these inspectors don't have either the expertise or a lot of the local jurisdictions may not have the capacity really to sort of train folk to know what this problem is and to determine whether or not it's dangerous mold or not dangerous mold. If any mold can ever not be dangerous. And so this is often lost then in the shadows. And so I'm glad that there's going to be some recognition that this is in fact a problem. The concern that I would have is that there seems to be perhaps, and maybe I just didn't see it in the amendments, a step that's missing. And of course, the step that's missing is that when the inspector refers it to the landlord, and the landlord goes out to get this qualified inspector, and the inspector goes out to make this report, I don't see that there's anything that requires then that qualified inspector to deliver that report to the tenant and the property that is subject to the inspection. And I'm assuming then that if the landlord receives that report, they're going to do some remediation. The problem with a lot of these laws is that, you have someone like Mr. Greenfield who my knowledge of him, he is a responsible landlord, and he's going to do the right thing. And the problem, of course, is with those folks that don't do the right thing. And that's the reason why, we're here. And so we're really concerned about protecting folks in those situations where you have those folks who are quote unquote bad actors. And in answer to, I think that I probably didn't answer the question that was asked. So if you repeat that, let me see if I could answer it.
You can answer
So
mine, but go ahead, Ms. Morton.
my question had been, and the bill sets up a whole new statute to deal with rent escrow specifically for mold and mold remediation. And I was wondering why it was done that way rather than just, section 8-211, which has to deal with the dangerous defects. I mean, I think currently right now it lists lack of heat, light, electricity, lack of adequate sewage disposal facilities, infestation of rodents, existence of structural defects, existence of any condition which presents a health or fire hazard. I was wondering whether it would be, quote unquote, cleaner to just add the existence of a mold hazard, as defined in, as if we're asking MDE to set up this kind of definition, or if there's a reason why it belongs in sort of its own statute, or whether kind of pulling it into the existing escrow statute would make sense.
Well, I guess the only reason why, and I'm guessing, I'm speculating because I don't know, I haven't talked to Delegate Henson about why she made that particular choice. But certainly if it was placed within the rent escrow 8-211 sort of regime, or any of the local jurisdictions rent escrow statutes, it's something that could be made to work. I would guess the reason that she would want to do that is particularly because of some of the issues that Mr. Greenfield pointed out, and it may have to do with the way that oftentimes rent escrow is not triggered, in particular by the tenant. It's triggered because it may be triggered by the tenant because the tenant withholds the rent, and then the landlord files a failure to pay rent, and so it becomes then an issue that involves what amount of rent is due and owing to the landlord. I guess with this, my only guess would be that it wants it to take those sort of this action out of that sort of process that's set up. It's designed to be quick. Mr. Greenfield and I will disagree as to whether or not it's quick or not, but it's designed to be quick, and perhaps it's set up to take it out of that particular arena where you're going to have potentially have a lot of people who are there on that day, as it involves fair to pay rent actions, to put it in another setting to be assigned to perhaps to another judge so that they can in fact have the time to sort of consider the problem.
Okay. So we have a kind of a straw person set of amendments before us. If we can see from kind of the stakeholders that are on this call, if there are any specific concerns, using that as a starting point that they don't feel comfortable with, and maybe work from there.
Mr. Chairman, I would just again reiterate this issue of the conduct of the tenant. The bill as designed, even with the amendments, sort of place the penalty, everything sort of is based upon the landlord's responsibility. And I understand that from a property standpoint, but from a penalty standpoint, it's an issue. Again, I think we need to figure out how we account for the conduct of the tenant, should the tenant be the one responsible for creating the mold. And I think that is sort of our fundamental problem, and how you address that is absolutely critical. We would also agree with Ms. Morton's, Ms. Morton's question, I think, is a good vision at all. We would also agree with MACO and MML. Not all rental units need to be inspected. It's important to note that jurisdictions don't inspect all units now in their annual inspections or biannual inspections. They are based oftentimes, at least from our perspective, based on a sliding scale. So that is, something that we would not support, having all of it. I'm not sure that anyone has quite the capacity to do it in any of that.
So I know Senator Pinsky's version had a provision in there that could, if it was found that the mold was the result of an action by the tenant, that it could be reimbursed through that kind of a mechanism. That would address kind of that first concern that you brought up, right?
Correct, and I apologize. I just received the chairman's amendments and haven't looked at it closely yet. But it sounds like that would address it, assuming we can collect it from the tenant, which is a separate issue.
Mm-hmm. Okay. MML Mako and Mr. Welch, I presume that since you were the ones kind of compiling and offering this, you're comfortable with this kind of straw person version that's before us?
I think this is a really good starting point. I think limiting the inspection burden on local jurisdictions is something we're absolutely looking forward to, and I think we're looking to find a reasonable role for local government here. The escrow portion of the bill isn't necessarily our expertise, and so we would defer on that portion. But I think this is a good starting point for us.
Okay.
So as an advocate, I'm sorry, Mr. Castelli. I'm sorry.
Yeah, Mr. Castelli, why don't you go, because we haven't heard from you first. Go ahead.
Thanks, Mr. Chair, members of the committee. Bill Castelli with the Maryland Realtors. And I would say we embrace some of the concerns that Aaron raised. We've talked to property managers. A lot of our folks do single family property. They may be running dehumidifiers in the basement. Tenant turns it off. They don't want to pay the electricity for the dehumidifier. That results in mold problems. So there's lots of conditions like that. You may have an interior bathroom, they don't run the fan. So, I mean, there's lots of like little conditions like that. And I'm not exactly sure how you account for it. One of the more basic concerns that we have though is, we don't really, if we're moving away from county inspectors, we're going to go to essentially private inspectors. We don't really know exactly how they're going to be certified. We're not really sure at this point what that inspection is going to require. Is it just a visual inspection? Are they going to be, digging into paint to test the mold? We don't even know exactly apart from the mold that's listed here, we're not exactly sure what level of mold is going to trigger what kind of remediation. Is it going to be a cleaning regimen, and what triggers a cleaning regimen, as opposed to, which has happened on some properties that our folks have managed, a $30,000 remediation because you've got to tear out walls, ceilings, and do that. So, I mean, having some standard of, what's that? And it's hard for us at least to judge, exactly what that's going to look like when we're not exactly sure about what those standards are yet.
Okay. Mr. Countess, you had something brief to say?
Yes. So I think that from the other side, I'd have the same issue or concerns about this private inspection regime. I think I put in the chat who's going to regulate the qualified inspectors. Again, just to emphasize that in the rent escrow process, this is an inspector that is being paid by the county to enforce county health and code provisions. So that person is a third party and uninterested really in the outcome of the proceeding, other than identifying the issue and asking that it be repaired. So I have some concern about that. Also, if they're going to do this report, they're going to be hired by the landlord. There should be a requirement that they provide a copy of their inspection report to the tenant. It may be there and I haven't seen it, and if so.
Yeah, I mean, I think that's something we can consider, that just adding a provision in there so a copy of the report goes to the tenant. Senator Galvan, you had your hand up.
Thank you, Mr. Subcommittee Chair. Just kind of listen to everybody go back and forth here. It seems like there's a lot of concerns on both sides. I'm just curious how much effort do we want to put into this right now to try to fix this whole thing? Or do we potentially say, hey, why don't you try to get these groups together and bring something back next year? I mean, we could talk this thing back and forth, honestly, all day. I don't know how far along we're going to get. I mean, at some point, do we look and say, well, maybe we vote this down this year and they can come back with something next year? I was just wondering how long how much time we wanted to invest in this. That's all.
Mm-hmm. Yeah, so it's a good question. I know we're nearing the end of the hour and I don't want to go much beyond that. I think, there were a lot of questions that were kind of brought forward and some requests for, provisions, for example, from Senator Pinsky's version to be brought over into the one that you're considering right now as kind of the straw person version, as well as, concerns that, for example, Mr. Countess brought forward too, that, I think we can try to address in a future version. I think, the problem is, real and the sponsor has tried to address this over multiple years, right? And so this is not the first time that this has come forward. I think we want to at least lay the groundwork for there to be an effort to try to address the actual root of the problem here with mold that can be present and making sure that landlords are responsible in addressing these concerns that are brought forward. I think we all are in agreement that the regime that's kind of proposed in the original bills is just too far, but can we find, some ground to at least advance the ball forward to that we can, see how that resolve some of the issue over the next year or two before considering whether or not further steps need to be taken. I don't think we have a solution at this time. Maybe it's something where, the committee council and I can sit down and add some provisions into this latest version from Delegate Henson, and then we can shop it around to the advocates, and we feel that there's potential to move forward with something more, that we can reconvene the subcommittee. Any other thoughts or questions from Mr. Lewis? You have not spoken yet, so why don't you go ahead and have a last word?
Yeah, thank you for that and for spending time on this. There were some questions posed about the rent escrow process and whether or not it's worth not worth, whether or not it's intentional that it's a duplicative process. And I do want to note that I do not have the answer to that, but I do have colleagues that I'll take this back to. And so if it's okay, I will confer and then bring back an answer to the subcommittee if that's okay. The other item that I wanted to discuss, because I'm not sure if it's in there, but I take Mr. Greenfield's point about the role of the tenant in the concern about the tenant having a role, and I'm wondering if it'd be possible to include some sort of educational material about what causes mold in the lease, so that there is at least some knowledge about there is some knowledge and education conducted for the tenant to know what type of actions would cause mold, so that it's not, because I think there is a barrier and an education gap there that should be solved for as well. So I'm curious about what the take is on that, and I would love the opportunity to follow up on some of the other outstanding points that were raised during the meeting.
Okay, so Mr. Greenfield, anything briefly to respond to that before we adjourn?
No, Mr. Lewis raises a good point, and it's one I'd like to go back and take a look, because some of these leases may already contain that kind of information. So let me report back to the subcommittee. and get you that information.
Okay, I see Senator Croza has her hand up. Final
I do.
comments?
Thanks. And I just wanted, your last comments, Senator Lamb, I just want to make sure I understood them. What I'm hearing is that the detail of this bill and trying to come up with specifics, it looks like it's a little bit too much for this session, but am I hearing you say you're looking to see how to lay some groundwork for, starting to put a process in place? I just, when you said we're going to recirculate something, I was just trying to understand, based on what the chair mentioned at the outset of the meeting, of recognizing it as an issue and then knowing that it sounds like this isn't ready for prime time. I think all of us are acknowledging that. So was just trying to figure out how we're leaving this, just to make sure I understand.
Yeah, so in closing, I think, obviously the version that the sponsor put forward does need a lot of work. I'm thinking that if we can find something that, the stakeholders in this meeting are comfortable with, to at least take some of the first steps to addressing the concerns that have been brought forward by some of the advocates, that would be a way to at least lay the groundwork for further examination of this issue later on. That this issue has come forward over multiple years. This is not the first year that, we've seen this, and it will continue to come forward. And if we can find some way to at least advance the some of the basic provisions of trying to address the problem, I think that would at least help us in taking a step forward. Because I agree, we're not going to solve this whole thing right now, nor likely in this session. So, but if there's something that we can come together on to move forward with, I think we want to try to do that. And I think what we're going to do is I'll sit down with council to see if there's some additional provisions that have come forward from this meeting that we can craft together, share it with some of the stakeholders here. And if there's sufficient consensus with those provisions, to recall this subcommittee to address those. But if the gap is still wide, I'm not going to call the subcommittee back together, to have another session where we can't get to a conclusion. Okay. All right. Anything else from the members before we adjourn? All right. Sounds good. Well, thank you for attending. Appreciate it. This adjourns.
Thank you for the invitation. Thank you so much.
Thank you. Have a good evening.
Good evening now.